Today we're going to talk about how to defend the AR-15 in a debate, and we're going to go over some First Amendment, you heard that right, some First Amendment concepts, something known as the Heckler's Veto. And we're going to talk about how to use the Heckler's Veto metaphor or concept from the First Amendment context. We're going to apply it to the Second Amendment context to help you defend the AR-15 and all guns for that matter when you fight for our right for freedom and the Second Amendment. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new law review article in the Georgetown Journal of Law and Public Policy entitled Dangerous but Not Unusual: Mistakes Commonly Made by Courts in Post-Bruin Litigation. Check it out. It's totally free. You can link to the Georgetown School of Law website and download a copy for yourself. About 60 some odd pages of detailed discussion, very scholarly, very historical, detailed defense and application of the Heckler-Bruin methodology. Check it out if you want to get geeky. A lot of good information in there, a lot of citations and footnotes for you to check out if you want to look at other sources as well. Check out my review, or I should say my law review article in the Georgetown Journal of Law and Public Policy. All right, folks, so this is an important video. It's not going to be very long. I'm going to give you a very important argument here. This is an argument I have not seen actually made in public. I haven't looked extensively to see, but I don't think it has been. I'm going to connect some dots here. In the First Amendment context, you all know that the Bill of Rights was adopted and went into effect. The first 10 amendments of the Constitution of the Bill of Rights. It went into effect the year of our Lord, 1791. A few years after the original Constitution went into effect, the Bill of Rights was adopted. The Bill of Rights obviously includes the Second Amendment's right of the people to keep and bear arms shall not be infringed. You're well aware of that. You're also well aware of the First Amendment, which has a series of protections and codifications of certain rights, including the right to free speech. Now, there is long-standing law involving the right to free speech. The right to free speech in the First Amendment has been litigated and fought all the way to the United States Supreme Court over and over and over again over the last 50, 60 plus years, even longer. In contrast, the Second Amendment is still developing in terms of its case law because we only have had 5 decisions, let's say, in the 21st century that speak directly to the Second Amendment. Heller, McDonald, Bruin, Caetano, Rahimi. You get the point. Now, the reason why I mention that is I'm going to provide you with a legal argument that is quite prevalent in the Supreme Court's jurisprudence touching on the First Amendment's right to free speech. This concept is known as the Heckler's Veto. The Heckler's Veto. What is the Heckler's Veto? Well, to understand what a Heckler's Veto is, you have to just be reminded, of course, what or who is a heckler. Well, if I get up to give a speech, let's say, in front of 1,000 people, okay, and I start my speech and there's one guy in the room, one person in the room, that jumps up and starts screaming and screaming and screaming so that nobody in that room of the 1,000 people can hear what I'm saying. What you basically have there is a form of a heckler's veto that infringes upon my right to free speech. Because my right to free speech also includes your right to listen to what I have to say. So if some heckler jumps up and down and makes a ruckus and prevents me from being able to be heard by you and prevents you from being able to hear what I'm saying, both of our rights to free speech, the right to listen, the right to learn, is being interfered with by this heckler. Now, with that said, the notion of a heckler's veto in the legal context, right? You understand what I just said is a heckler's veto. Like, for example, you've seen it on TV. There's like a comedian. He's telling jokes. There's somebody drunk in the back of the bar or the back of the club and starts heckling the comedian. You know how it goes. Now, in the First Amendment context, though, the heckler's veto has a specific meaning. And then we're going to tie this into the Second Amendment. You're going to like where I'm going with this. Trust me. The heckler's veto in the First Amendment context is an excuse if you will, for the government to suppress your speech. In other words, the notion of the heckler's veto is that a government will use the possibility of a heckler to suppress your speech. Specifically, the government would argue that because it's possible that there will be a violent or disorderly reaction caused by hecklers to my speech, that allows the government to prevent me or suppress me from speaking. Now, the good news is, as a matter of First Amendment law, while the First Amendment cannot prevent a drunk guy in the back of a comedy club from jumping up and down and heckling the comedian, that's not a First Amendment problem, because that drunk guy in the back of the comedy club is not a state actor. He's just a private dude. So the Constitution doesn't cover him or protect you from him because he's just a private dude. Now, there may be other causes of action or issues you can address, trespass or whatever. But as a matter of constitutional law, you can't stop him from interfering with you as a heckler. But what you can do in the context of the First Amendment's heckler's veto argument is the government is not permitted to say, because, here what I'm about to say, because we fear that criminals or hecklers or people may react violently, or they may react in an unlawful way as a response in reaction to Mark's speech, we, the government, can come in and shut down Mark's speech because we don't want the violent, unlawful reaction by the hecklers. So to prevent the unlawful, illegal, violent conduct or activity by the hecklers or the people that are going to misbehave in reaction to what Mark is about to say, we, the government, have the authority to stop Mark from speaking in the first place because we fear the effect of what Mark is about to say. Now, this is known as the heckler's veto. And what I've just described is unconstitutional, meaning the government may not censor me or suppress my speech because some other person over whom I have no control might misbehave or break the law in some way. The notion of the government cannot use the so-called heckler's veto possibility, or the heckler is a possibility to veto and suppress my speech, is not allowed under the First Amendment. So the question becomes, how does this notion of the government may not use the excuse of a possible heckler's veto to shut down your speech, how does this apply and help us in the context of our Second Amendment rights and our right to free speech and our right to keep and bear arms? It's quite simple. Let's just take it in the context of the AR-15 ban fight. We know that anti-gunners want to ban AR-15s. They hate these semi-automatic rifles because, as you know, an AR-15 is nothing more than an ordinary semi-automatic rifle. That's all. So the way I would argue this heckler's veto, and you can take this argument and you do your memes and you do your arguments and you do your fancy stuff out there, that's great. The way I would make this argument is really quite simple. If you look at the Department of Justice statistics in any given year, there's somewhere between 300 to 500 people every year all across America are killed by rifles. All types of rifles. All types of rifles. What I would do as simply math, I would say, even though we know the numbers between 300 and 500 a year are killed with all types of rifles, we're going to make the following two assumptions, just to keep the math easy. We're going to assume, for the sake of argument, that there's actually 1,000 people a year that are killed with all types of rifles all across America, even though that's not true. But we're going to assume it's 1,000 people. And we're also going to assume something else that we know is not also true. It's not true. That is that all 1,000 people that are murdered by rifles, that those particular rifles that they're murdered by are all, without exception, AR-15 or AR-style firearms, which we also know is not true. But let us assume, for the sake of argument, arguendo, that 1,000 people a year are killed with AR-15s alone. That's it. What does that teach us? Well, if you do the math, we know there is over 20 million AR-15s in America. Well over 20 million. But we're going to keep the math simple here. We're going to assume that there's only 20 million AR-15s in America. So let's do the math. All you have to do is take the number 1,000, which is our 1,000 rifle deaths with an AR-15, for the sake of argument. You're going to divide that, right? That's going to be your numerator. Then you're going to divide that by the 20 million AR-15s in America, which is going to be your denominator. So you're going to take your 1,000 divided by 20 million, and you're going to run the math. You're going to divide the 20 million into 1,000, and that's going to give you a number that's 0.9995. And then you're simply going to multiply 100 by that to give you a percentage, and you're going to see that it's literally 99.9999 or something like that of the AR-15s in America will have no connection to a murder in any given year. In other words, well over 99.9% of the AR-15s in the United States will have no connection to criminality in the United States in any given year. So if you're going to have the government ban the 99.99% of the AR-15s in the United States because of a few hundred bad apples misbehaving with AR-15s, you have engaged in a violation of our constitutional rights known as the Heckler's veto. You're saying the government is basically arguing that because a handful of hecklers, a handful of bad apples are going to misuse these firearms, we're going to ban all the Second Amendment rights to possess these firearms in the United States because some people will misuse it. In the same way that you're going to say that we're going to shut down all speech in the United States because there may be a heckler or someone may violently or unlawfully or otherwise misbehave as a result of your speech, so therefore we're going to shut your speech down. It's the same concept. And I'm happy to report that the U.S. Supreme Court in the Heckler case basically agreed with what I just said. They did not use the phrase Heckler's veto, but they used this logic. If you look at the Heckler decision 5-4 in favor of the Second Amendment, the dissent by now retired Justice Stephen Breyer, who I was with just the other night, a very lovely man, a very erudite man. Politically, Justice Breyer and I don't see eye to eye, as you can imagine, but a very erudite, sharp individual, even to this day, even though he's off the court and we don't agree on a lot of stuff. Nevertheless, I will say Stephen Breyer is a gentleman and a scholar, and that is a truth. That is a true. Even though, again, I don't agree with what he thinks about a lot of things, including the Second Amendment. With that said, Justice Breyer wrote a very powerful dissent attacking guns, saying that guns are bad and guns violence, and therefore we can have gun control. That dissent was rejected by Justice Scalia in the Heckler case because Justice Scalia basically said that we don't measure constitutional rights by how someone might misuse them. We focus on the lawful conduct of American citizens. And therefore, in the Heckler case, which was dealing with a handgun ban in D.C., Justice Scalia said, look, Americans overwhelmingly, for whatever the reason, choose handguns to be the quintessential weapon of self-defense. So Justice Scalia is focused on the lawful use of handguns, while the dissent, Justice Breyer, was laser focused on the criminal conduct. So basically, Justice Breyer was embracing a form of Heckler's veto, which of course I'm happy to report did not win the day in the court, while Justice Scalia was essentially embracing the First Amendment jurisprudence of the Heckler's veto, which says even if someone might engage in improper conduct as a result of the speech, the exercise of the First Amendment right, or the exercise of the Second Amendment right, that is not a basis for oppressing, suppressing, or shutting out the constitutional rights of the lawful Americans that benefit from those rights. We measure constitutional rights by how they're used by law-abiding Americans, and we don't restrict them because they may be misused by criminals or other people that don't follow the law. That's just not how constitutional rights are defined. That's not how the scope is articulated, and that's just not how we view the Constitution from the perspective of enforcing the Bill of Rights at the court level. So there you have it. I hope you learned a little bit something here today about the Heckler's veto and how it can be used in favor of the Second Amendment. Make sure you remember this argument. Don't forget to follow me on X at 4Boxes Diner. Make sure you like this video and subscribe. And I look forward to seeing you all very soon here at the 4Boxes Diner.
Orders up. Table 2A.